Will the Committee on Executive Matters and Legal Affairs please come to order? It's 2:32 p.m. I'd like to welcome Committee Vice Chair Cordero, Council Vice Chair Kiaina, and Council Members Tupola, Wire, Okimoto, and Talba. Council Members Say and Waters are excused. Before we start our meeting, I have some procedural announcements to make. Pursuant to Section 92-3.7 Hawaii Revised Statutes, this meeting will be conducted as a remote meeting by interactive conference technology with the following procedures in effect for the meeting. Members of the public will be allowed to provide oral testimony remotely or in person in the council chamber on all items on the agenda when each item is taken up. All persons who registered to testify in person will be called upon first, followed by those who registered to testify remotely. Before testifying, each person shall state their name. Each speaker may not have anyone else read their statement and is limited to a 1-minute presentation on each item. For remote testifiers, when your name is called, please monitor your screen and activate your audio feed when prompted. For those who are joining us by telephone only, please press *9 to indicate your desire to speak. All registered testifiers will be called upon first. Then I'll give persons who have not registered an opportunity to speak following the oral testimonies of the registered speakers. Please utilize the raise hand feature in Zoom to be called upon. HRS Section 92-3.7 contact with you and cannot reconvene until we reestablish contact. Therefore, please announce beforehand if you're voluntarily signing out of the meeting. Written testimonies, including the testifier's address, email address, and phone number, will be available to the public as described on the posted agenda. Please note that agenda item number 2, Resolution 24-35, has been canceled and no testimony or discussion will be taken. We'll take that up at a future meeting. I'd like to welcome Councilmember Say. And finally, as a courtesy, please turn off all cell phones for the duration of this meeting. We're going to start with Resolution 24-49. This is agenda item number 1. This urges the mayor to issue a proclamation declaring the city and county of Honolulu a Purple Heart City and county to express gratitude for and honor the service and sacrifice of members of the United States Armed Forces who are wounded or killed in the line of duty. We have with us Andy Sugg, Chief of Staff.
Thank you, Council Chair and Council members. Andy Sugg, Chief of Staff for Mayor Blangiardi. The Mayor is very proud to support this resolution proclaiming the city and county Purple Heart City. This will honor the servicemen and women of the United States military who have been killed or wounded in action, and the more than 1.8 million Purple Heart recipients. The Mayor's received a request for an August 7th proclamation. Mahalo.
Great. Members, any questions? Okay, seeing none, we'll proceed with in-person testimony. Clerks, do we have any in-person testifiers or anyone else in the chamber who'd like to testify?
Chair, there are none.
Okay, and we'll now proceed with remote testimony. I see Angela Melody Young has her hand raised.
Aloha, Angela Melody Young. I'm testifying in strong support on behalf of CARES. In strong support of the Purple Heart resolution. War is bad. As we witness violence around the world, it is time to mourn the wars and the time to commit once again to rebuilding a culture of peace. War is traumatic because it often involves violence, including witnessing direct combat, viewing the enemy getting harmed, and seeing friends and comrades pass away. War injures and disables the ones fighting to protect our nation and our community. It causes high levels of post-traumatic stress disorder, PTSD, and can lead to moral injury as well as deep shame, guilt, anger, or anxiety. War destroys the natural environment. It destroys natural habitats. War's financial cost is enormous, and war also does set back development. The destruction of homes, schools, and hospitals, as well as transportation, electrical, water treatment, and sanitation systems.
Thank you. Members, any questions? Clerks, do we have any other remote testifiers standing by?
Chair, there are none.
Okay. There being none, members, we are in discussion. Members, any discussion? Councilmember Talba.
Thank you, Chair. I just wanted to say thank you for hearing this, and I wanted to also thank Takumi Abe and the members of the Purple Heart Rainbow chapter for the opportunity to have them, here, and also to honor them and those who have fought in the wars for us. And I am deeply and grateful for all the sacrifices of all the men and women who have served, and I'm looking forward to seeing this move forward.
Thank you. Vice Chair Kiana.
Thank you, Chair. Thank you, Councilmember Toba, and thank you for the mayor for supporting this. My father was a Purple Heart recipient during the Korean War, and he barely made it off of the peninsula field. And it was very difficult conditions, especially when it got very, very cold. And I do know that a lot of the men from Hawaii had a hard time. And so I do know, when you are a Purple Heart recipient, the whole family's impacted because you have nightmares, you have PTSD, not only for the physical and emotional pain that you went through, but of course, many of their friends were lost on the field. And so I think it's just a good reminder for us. I know we have Memorial Day and Veterans Day, but it's a good time for us to remember those who have suffered and continue to suffer from all of the various wars, including modern historical time. So thank you guys very much.
Thank you. Members, any other discussion? Okay. Seeing none, we'll proceed to my recommendation. Chair recommends that Resolution 24-49 be reported out for adoption. Any discussion, any objections or reservations? Hearing none, so ordered. Members, with your indulgence, and if there's no objections, we'll move to item number 4, which also relates to the city and county of Honolulu being a Purple Heart city. We'll take that up and then we'll come back since we're on the same topic. So we'll skip ahead to agenda item number 4. This is Bill 7 of 2024, which relates to declaring the city and county of Honolulu a Purple Heart city. We again have with us Andy Sugg, Chief of Staff.
Thank you again, committee chair and members. As I said, the mayor wholeheartedly supports this bill and wanted to give a special mahalo to Councilmember Toba for introducing it. So thank you.
Thank you. Members, any questions? Okay, seeing none, we'll proceed with in-person testimony. Clerks, do we have any in-person testifiers or anyone else in the chamber standing by to testify on Bill 7?
Chair, there are none.
Okay, there being none, we'll proceed with remote testimony. We do have a telephone testimony from 714 and then ending in 175. So if you could unmute yourself. This is Tim, okay. Tim, if you'd like to testify, please unmute yourself. It may be *6. Okay, well, if Tim would like to testify, we'll take him while he figures that out. In the meantime, we'll go to Angela Melody Young.
Aloha, Angela Melody Young. I'm testifying in strong support of the Purple Heart law. So we should enact this law because we should stand up against war in this generation while honoring those that have fought in the last generation and the knowledge that they've bestowed upon us. War distorts truth. War promotes prejudice and stereotypes of those considered the enemy and often portrays the enemy as less than human, delegitimizing the use of violence against them. War reduces moral categories to the simple binary of we are good and they are evil. Nuanced public discussion becomes increasingly difficult and sometimes impossible. The Purple Heart, originally called the Badge of Military Merit, was a purple-colored and heart-shaped badge created in 1782. And the Purple Heart is the oldest decoration to honor all those who were wounded. And so we should really support this law. Yeah.
Thank you. Members, any questions for the testifier? Okay, seeing none. And I also see that the testifier who's number ends in 175 is no longer on. Clerks, is there anyone else standing by remotely to testify?
Chair, there are none.
Okay, members, we are in discussion. Any further discussion? Okay, there being none, the chair recommends that Bill 7 of 2024 be reported out for passage on second reading and scheduling of a public hearing. Any discussion, objections, or reservations? Hearing none, so ordered. All right, now members, we're going to go back to agenda item number 3, which is Bill 26 of 2022, CD1, which clarifies gifts to the mayor, prosecuting attorney, council members, and city officers and employees. Members, we do have a posted proposed CD2, which is OCS 2024-0216 to the bill, submitted by myself. For your information, a summary of the amendments is listed on the agenda addendum. We do have the Ethics Commission here to testify. If we'd like to bring up either the director or deputy director to testify. And if you could introduce yourself. Thank you.
Aloha and good afternoon, Chair Dos Santos Tam and members of the Executive Matters and Legal Affairs Committee. My name is Lori Wong Nowinski, and I'm the Assistant Executive Director and Legal Counsel for the Honolulu Ethics Commission. Mahalo for the opportunity to testify today to provide comments on Bill 26, 2022, proposed CD2. We stand on our written testimony, which I will now briefly summarize. The Ethics Commission's objective has long been to clarify and strengthen the city's gift laws. Given the recent city corruption scandals that have resulted in federal convictions over multiple departments, the public is in even more support now to further the Commission's objectives, which again is to clarify and strengthen the city's gift laws. While we support the proposed CD2 in its intent to move the bill forward, we want to ensure that it does in fact decrease the amount of confusion so that city employees know when they can and cannot accept a gift. We do not want them to fall into any kind of pitfalls. I'm going to now turn to our specific comments that we have in regard to this proposed CD2. And I also want to note that we do understand that there may be some modifications to the proposed CD2. However, we will just proceed with our current written testimony. First, turning to the definition of prohibited source, we are concerned that the current definition as proposed is too narrow, as it contains the terms current and substantial financial relationship with the city. In all of the peer jurisdiction research that we had looked into, none of the other jurisdictions had this sort of limiting language. And we would also like to bring the committee's attention to the fact that Section B in this law prohibits city officers and employees from accepting any gifts if it appears that the gift is intended to reward or influence the city officer or employee in completing their official duties. So when you look at the terms reward or influence, that implicates either possibly something that may happen either before an official action or after an official action. So by limiting the terms to current and substantial financial relationship with the city, it kind of eviscerates that first subsection B. So we have some concerns with that. Secondly, we also have some concerns with the new added section, subsection C of proposed CD2, in that it appears to create a separate class of city employee, specifically those who have the authority to approve city applications, permits, registrations, licenses, and so forth. And it seems to allow them to accept any gift so long as they disclose the conflict or disclose the gift and recuse themselves from the transaction. So it seems like that would get rid of the conflict, but it in fact, instead of preventing a conflict of interest from happening, it actually encourages a conflict, or maybe not encourages, but perhaps it allows conflicts of interest to happen. We are concerned that this type of allowance would create a type of situation where business relationships can flourish, because as you probably all will know, business relationships do not happen in a vacuum. It happens over a long period of time, and as far as those DPP employees who were federally convicted, it took years, some of them even decades, of relationships that they formed with permit expediters, architects, and engineers, and it's a series of transactions that happen. So we don't think that this subsection C would assist with that, and it's targeting the very class of employees that were subject to the federal convictions. In regard to the section in regard to allowing gifts up to $200 per year per source, we believe that it should be decreased to $50, and we understand that perhaps in a future draft that may take place. And again, that's according to our peer jurisdiction research. The next section was in regard to gift reporting. That again may become a moot point. While we do support transparency, we do believe if there is going to be reporting required, that the City Ethics Commission would need additional resources in order to fully carry out this mandate. And finally, the same thing goes with training. If we want to create training for a gift reporting requirement, that may need to be delayed in implementation so that we can create a new video for the 2025 biennial training period. Mahalo so much for listening to that long testimony, and I'm available for questions.
Thank you. And for the record, members, the Ethics Commission's testimony is available as Departmental Communication 137. Members, any questions for the Assistant Executive Director? Okay, seeing none, thank you. We'll now proceed with in-person testimony. Clerks, do we have any in-person testifiers or anyone in the chamber who'd like to testify?
Chair, there are none.
Okay. Clerks, do we have any registered? I see we have one registered remote testifier. We'll proceed with David Monk.
Aloha, Chair and members of the committee. Thank you very much for hearing this bill. I would just like to express not only my support, but I think the unanimous support of our commissioners for the testimony that was just given by Lori Wong-Nowinski. We share the urgency of updating and clarifying the gifts law, and also we believe that the concerns expressed about particular sections of the CD2 draft are justified, so we hope you'll take those very seriously. I'd also like to just publicly acknowledge the peer jurisdiction research that Ms. Wong-Nowinski referred to was primarily done with the voluntary assistance of University of Hawaii at Manoa Professor Deborah Halbert, who is the Vice President for Academic Strategy at the university, and she did a very thorough and substantial survey of mainland peer jurisdictions, which greatly helped us in drafting our proposed language. So thank you to her, and thank you, Chair.
Thank you. Members, any questions for Commissioner Monk? Okay, there being none, we'll move on to our other remote testifier standing by. We'll start with Tim Gary, ending in 175. Yes, please proceed.
Hello, good afternoon. I'm opposed to this bill, and I believe that anybody in the city shouldn't even get $50 gifts, period. One of our old councilmen, Rod Tam, got in trouble over small $50 gifts. And it's an influence. You all get paid enough now to where you shouldn't be receiving any gifts. I think it should be zero. You can get some lei and that's it. Otherwise, it's influencing. And that's about it. Thank you for your time.
Thank you. I appreciate that. Members, any questions for the testifier? Okay, seeing none, we'll move on to Angela Melody Young. Please proceed.
Aloha, Angela Melody Young, testifying, wishing to comment on behalf of CARES. So according to the law as it is written now, the revised ordinance of Honolulu Chapter 3, council members and staff can accept gifts which do not exceed $200 per calendar year. So that is in the city law right now. And according to the city's Ethics Commission's revised guidelines of gifts, which is like an outline summary of the revised ordinance, council members and staff may accept small tokens of aloha, such as goodie bags, snacks, and food. The city's Ethics Commission has clear guidelines about gifts. And on page 5 of the revised guidelines of gifts, there are guidelines for officers and employees, and the guideline states city personnel, except for those who have the authority to enforce the law, so law enforcement, except those who can enforce the law, may accept small tokens of aloha, such as food or lei to be shared, especially during the holiday season. So, this bill as proposed is defining a gift of negligible value. So I think it's good to kind of set the parameters. And it also does set a limit to prohibited sources. And there should be clarification of lobbyists as defined by the city ordinance and the Hawaii Revised Statute, because HRS Chapter 97 clarifies lobbyists are those who get paid $1,000 or more to conduct advocacy. The city defines it in a different way. Volunteer lobbyists, such as myself, who do not get paid to conduct advocacy, are technically not lobbyists according to the state law. So I think it'd be good to kind of like set the limit within this law if
Thank you,
they're going to go with that.
Thank you. Members, any questions for the testifier? Okay, seeing none, is there anyone else standing by remotely to testify, clerks?
Chair, there are none.
Okay, there being none, members, we are in discussion. Members, any discussion on this bill? Okay, there being none, the chair is going to recommend that Bill 26 of 2022, CD1, be amended to the posted proposed CD2, OCS 2024-0216, with 3 changes. So on the summary sheet, we're going to take the recommendations that were posted, but we are not going to do sections B8, B9, or recommendations B8, B9, and C on the summary sheet. And this is in accordance with the Ethics Commission's testimony. What this would in effect do is put in the $50 amount for negligible value. It would also delete the subsection F relating to gift disclosures, since that wouldn't be necessary, by replacing the $200 annual cap on gifts. And this would also eliminate the training requirement relating to the new gift disclosures, since we are getting rid of the proposed language for the new gift disclosures. I think what this does is this helps to streamline the overall ethics policy for the city. Right now, as it stands, the City Council has its own policy in ROH 1993-8.8, and the rest of the city employees have their own policy in 3-8.7. And so by bringing it all together, I think that this helps further the goal of transparency and having the highest ethics possible in government. So that's the chair's recommendation. This does go out for 3rd reading, and at which point, if there's any further changes, we can make those there. But that's my recommendation. Is there any discussion or questions on that, Vice Chair Kiaina?
Yeah, I'm sorry. I just want to clarify. So Which items, again, are you addressing, and which one are you not?
Correct. So the recommendation is to do everything on the summary sheet except for B8. If you're looking at the Ethics Commission's testimony, we would eliminate items B8, B9, and C as they relate to the Ethics Commission's testimony. The Ethics Commission thought in B8 that the aggregate up to 200 per fiscal year was too high. The Ethics Commission thought that the gift disclosures triggered by that would create additional workload, and so we're eliminating that. And then item C, that if we have these extensive gift disclosure provisions that are triggered by this, they would have to do additional training development. And so if we eliminate that, that goes away.
Okay, and with regard to the other ones, the other items, B5 and
Yes.
B7, is that, you're just mulling it over, considering their
Yeah,
recommendations?
so we'll take those under advisement. I think I understand where the Ethics Commission is coming from with the definition of current and substantial financial relationship. And I do note that it's defined, as they note, in the section of, who a prohibited source is and who, from whom sort of the gift is intended to influence or, be a reward. So that's covered there. It's just really those words, I think current and substantial. And then for B7, I think the issue there, as I understand it, is, the Ethics Commission wants to be abundantly clear about, that there be no conflicts of interest whatsoever. And in considering my recommendation, I think it's important to recognize that there are times when conflicts do happen, simply not out of any nefarious reason, but because the policy affects a city employee's spouse or their children. These things do come up, not intentionally, and it's important for us to have some kind of disclosure mechanism and some kind of mechanism for that city employee whose maybe spouse, by no intent of their own, creates a conflict to disclose that and recuse themselves as a city employee. I think without that, disclosure, it's very difficult to know what's going on, and I'd rather have a disclosure and a process for that city employee to remove themselves from the situation than not.
Chair, so yeah, I clearly support this. In fact, I actually thought it was negligible already. I wasn't even aware of the $200 threshold amount, because I think we've already been abiding by negligible value. I will say this, however, that this in and of itself is not going to be deterring undue influence by, all city employees. And I just highly recommend that for certain areas, including the Department of Permitting and Planning, that you work with the leadership of those agencies to work on other areas, because including automation, for example, where you're not giving the discretion to an employee to be to overseeing things that may not be input into the system, and that wouldn't be fair for those applicants who are putting things forward and their application is not moving forward. So that's all. I just wanted to say that this, I welcome this bill, but it in and of itself is not going to be resolving all of the problems. And so I just want to make sure that you look beyond this and get to the crux of the problem in certain agencies. And I'm quite certain that there's a lot of auditor reports to give you guidance on, some of the efficiencies and inefficiencies of some of these departments. And I hope that you guys can get to the root of it. Thank you.
Thank you. I think we're all in agreement with that for sure. Members, any further discussion? Okay, any objections or reservations to the recommendation? Councilmember Say, reservations. Reservations from Councilmembers Say and Cordero. But hearing no further objections or reservations, so ordered. Thank you, members. So we have already done agenda item number 4, so we'll move on to agenda item number 5. This is Bill 8 of 2024. Oh, sorry. Before we move on to that, Chair then recommends that Bill 26 of 2022, CD2, be reported out for passage on third reading. Any discussion, any objections to reporting it out for third reading? Any reservations? Hearing none, so ordered. Thanks for the reminder. All right, now on to agenda item number 5. This is Bill 8 of 2024, which relates to community workforce agreements. We have with us Managing Director Mike Formby.
Good afternoon, Committee Chair, Council members, Mike Formby, Managing Director. The administration stands in support of the bill. Primarily, we're concerned with opportunities to resolve ambiguities in construction. And I will say that we've been working with signatory union members for some time on this, trying to achieve a better and more efficient processing of these community workforce agreements, and we still have a ways to go. I had set up a training with the departments actually last week, and we had to postpone that training because we had so many questions about the process, and so I need to get more information for the departments. But there also were some questions about the proposed language, and so I would like the opportunity to get with the departments, get more information and input from them, and at the next committee hearing, possibly share some concerns. But the administration's position is that to the extent we can separate covered projects from operations and maintenance, that is the goal, because historically that has been the problem. And specifically, it related to the fact that the first part of covered project talks about new structure, new infrastructure, but then the end of that paragraph includes the phrase new infrastructure, and it just caused problems in construction. So we support the attempt here by the council to clarify and reduce ambiguity in construction, and I'm happy to answer any questions you may have. Thank you.
Thank you, members. Any questions for the Managing Director? Okay, seeing none, thank you. We'll move on to in-person testimony. We have first Jeffrey Almeida from the Associated Builders and Contractors.
Thank you. Aloha Chair, aloha Council members. My name is Jeffrey Alameda, President and CEO of the Associated Builders and Contractors. Since 1989, our organization comprised of over 170 member companies has represented non-union contractors, which make up 61% of all of Hawaii's state licensed contractors. We stand in opposition to Bill 8 related to Community Workforce Agreement. Redefining capital improvement projects and the Community Workforce Agreement will impact these businesses, including many minority and women-owned businesses that have been historically underrepresented in the industry. This bill will increase business costs, limit the pool of companies that can compete for these projects, and require employees to contribute to benefit programs they may not be eligible for. On behalf of our member companies, we firmly ask that you oppose Bill 8 relating to community workforce agreements. Mahalo.
Thank you. Members, any questions for Mr. Alameda? Councilmember Tolba.
Thank you, Chair. Hi, Mr. Alameda. Just a couple questions. Can you share with me an example of how this bill will impact contractors' business, and what is the impact on an employee of a non-union contractor working on a project subject to the Community Workforce Agreement?
Thank you, Council Member. I appreciate the questions. I'd like to start with the latter question, and I'd like to provide an answer by sharing a story. Recently, one of our contractors shared a story about one of her carpenters, an apprentice in her first year in the industry, working on a public works project, earning about $20 an hour. As per prevailing wage guidelines, she is eligible for an additional $9 per hour in fringe benefits. That's about $18,000 a year. Normally, this worker would receive the benefits in cash. It's tough to make ends meet in Hawaii, so that additional payment is very important. Yet under the CWA, she is required to contribute that money towards fees that are mandatory for workers under CWA agreements. And in most cases, these are contributions she may never be eligible to receive or benefit from. With regards to contractors, last night in a conversation with the president of a women-owned business, she shared with me that 3 of her employees left. And it was a sort of a wonderful news, not so good news story. The reason they left is because they needed the fringe benefit paid in cash. And that's a benefit that you would normally receive on prevailing wage projects that are not part of the CWA. She's awarded a project, yet she has to go out and find 3 new employees, train them in order to complete the projects. Non-union contractors struggle with retaining their workforce because of these requirements. In addition, what's really important that we'd like you to understand is this threshold is such that it really makes it very difficult for non-union contractors to bid on these projects, to complete the projects safely, to complete the projects on time, and to complete the projects on budget. In these tough economic times, we strongly suggest that the language in this bill be stricken, the additional language, and we suggest that you come out. We'd love to invite you out to meet with our member companies to hear firsthand from them the struggles they have trying to do good business, earn a good living, and help support all of the many workers, the thousands of construction workers they benefit. Thank you.
Okay.
Thank you.
Councilmember, any other questions for the testifier? Okay, seeing none, thank you for your testimony. We also have Nathaniel Kinney from the Hawaii Regional Council of Carpenters.
Council members, Nathaniel Kinney, Hawaii Regional Council of Carpenters, in support of the amendment. Rather than go over the many misstatements that were made by the testifier before me, I'll just stick to the matter at hand. Probably most significantly, the thing that I have a trouble identifying is that the CWA was passed by this body 3.5 years ago, and has applied and should apply to all projects over $1.5 million. There's only been one project that the CWA has applied to, and that is the Honolulu, not Honolulu, it's a wastewater treatment plant. There was one project. So I don't understand if it only applied to one project, how non-union contractors are not bidding on contracts if it's only applied to one contract. So that's a mystery to me. Second of all, in a discussion with the United Public Workers, I'll finish up, this is my last statement. You cannot define something as maintenance, because if you define it as maintenance, then those projects should be done by the public workers. That's under the Kona decision. So if you define something as maintenance, it should be covered, those projects should be executed by public workers. If these are CIP projects, then they're not by definition maintenance projects. So that's why the reference is to CIP projects. So if you awarded projects and define them as maintenance, those projects need to have been done by public workers. Thank you.
Yeah, thank you. Members, any questions for the testifier? Okay, seeing none. Seeing none, clerks, do we have any registered remote testifiers or anyone standing by remotely to testify?
Chair, there are none.
Okay, there being none. Members, we are then in discussion. Members, any discussion on this bill? Councilmember Tupola.
Sorry, I don't know if the time has passed, but can I ask Nathaniel a question,
Of course.
please? I was thinking on it, mulling it over and trying to articulate it.
Sure.
So the CWA is roughly congruent to the PLA, right? On the state side, it's like, is
Almost exactly.
right? And then on the state side, I'm just trying to understand it here. I understood it there. On the state side, from what I understood, they could choose it or use it on certain state projects, UH. So you're saying that the law allows for projects 1.5 million and over, or does it mandate for projects? Where do I read that?
our understanding was that it was mandated on all projects $1.5 million and over. The Corp Council has decided to interpret the definition of maintenance to say that large CIP projects are therefore work that could be done by public workers, therefore they are all considered maintenance. So I don't understand. If something is maintenance, it should be done by public workers. If something is CIP, it's contracted out.
And your understanding about the 1.5 over that's mandated is for not for maintenance, but for CIP projects or for ground up projects?
Not ground up project, just any project that's over $1.5 million. And then it lists specific types of projects that it would apply to, just to be specific.
On the state side, didn't the PLA say that it only applied to like UH or something else like that, and then the state could use it or not? So on our side, it didn't say could use it or not. It said 1.5 million and over.
Are you talking about the 2012 project labor agreement?
Yeah.
Oh, I see. The 2012 project labor agreement could be used on projects.
Right. I thought that's what it said.
The state just recently, through an administrative directive that was published 2 weeks ago, now mandated that all projects over $1.5 million should be covered. And then sent out an administrative directive that says that all departments need to follow that. That was a recent development.
Oh, really?
Right. So we're not asking for anything different than what the state is doing.
Basically follow the law.
I thought it was pretty simple, and then we got this really convoluted explanation from CORE that it's like, oh no, well, these projects could be done by public sector workers, so therefore these are not covered by the CWA. And then when I talked to the public sector workers, they're like, we weren't awarded that project. So I was like, so what is it? It's either maintenance or it's capital improvement. It cannot be both.
Yeah. Understood.
That's what's a little disturbing, because I mean, if it's maintenance work and it was awarded to outside contractors, you guys might be getting a pretty big decision from the public workers saying, now you guys got to redo that all over, or you have to pay damages or something like that, because there's a whole Kono decision. I don't really know the ins and outs of that. It'd probably be better to go talk to them, but I just think it's very simple. CIP projects over $1.5 million should be covered by the CWA. That was the intent of it. And maintenance projects should be done by the public sector workers.
Understood. Thank you for the answer. Thank you, Chair.
Thank you, members. Any other, well, since we're in discussion, members, any discussion? Councilmember Say.
Anybody from the administration?
We have Managing Director Formby here.
I was just asking myself this question, Managing Director Formby. What is broken? What is broken that we have these amendments? If you can share with me, because I'm of the opinion that maintenance and operations, and correct me if I'm wrong, Mr. Kinney, is tied to collective bargaining. 3 years ago, if I recall, we did put in the budget $10 million for maintenance of our stream beds that are concreted. Are you then saying now we were denied because UPW said in the collective bargaining agreement you cannot hire an outsider to do the cleanup of our streams? Now this would say only public employee workers could do it? Okay, please, you're shaking your head.
Councilmember Say, Mike Formby. Actually, I don't believe the issue has ever been so much with operations and maintenance as much as it has with the covered project. And to me, because each department is responsible for enforcing the law as it's currently written by council, adopted in 2019, there's not uniformity among the departments on how to adopt it because they construe some of the language differently. And the way I look at it is, first, I don't want to openly correct Nathaniel Kinney, but I believe the law that's currently written is $2 million. I don't believe it's 1.5. So I believe it's $2 million, and we've been operating by that. But it basically makes it applicable. The community workforce agreement is to big-scale public work projects. And in the 2019 law, they used the monetary figure of $2 million, which is not that big of a figure for big public works projects. And so for some departments where they're doing projects that are maybe 2.5 or 3 million or $4 million, and they believe they're replacing something, they would define it as a replacement versus a new facility. And it just becomes very confusing. And I'll give you the example that I like to talk about, is that if you had an E&V project, a digester, and it had a cap on top, and that cap needed to be replaced. And replacing that cap might be $10 million to replace that cap. Because it previously existed, people interpreted covered project as replacing that cap would not be a covered project because you were replacing something that already existed. Whereas my feeling was, because it's in the CIP budget, and because it's not work traditionally done by public workers, and we go out and contract somebody to do it using bonds, and it is a new cap, it should be a covered project. But you could interpret it either way. So the purpose of the language that's being proposed is simply to deconflict construction of the existing law.
Okay, got it. Even though, thank you very much for your response.
Yeah. Members, any other questions or discussion? Councilmember Solba.
Thank you, Chair. I'll be voting with reservations because I'd like to learn more about the impact of these changes on union and non-union work.
Okay. Well, to that point, the chair will be recommending that Bill 8 be reported out for passage on second reading and scheduling of a public hearing. Noting the reservations of Councilmember Talba, are there any other reservations or objections? Okay. Hearing none, so ordered. Thank you, everyone. I also look forward to further discussion and clarification on exactly what this bill would do, especially in light of the existing CWA that was passed several years ago. All right, members, up next we have agenda item number 6. This is a review of the city's emergency operations plan for the legislative branch of the City and County of Honolulu, dated February 6, 2012, pursuant to Council Rule 10C. Members, I do want to make a minor correction to the title. The date in the title should read June 26, 2019, not February 6, 2012. This agenda item is on here because we are required to do a review of this every so often. I will note that we do anticipate the overall city emergency operations plan to come out sometime in the next few months. And so this is just on here for a brief review. If there are changes that need to be made in conjunction with the overall plan that's coming out, we can take those up then. So for the purposes of this and pursuant to Council Rule 10C, is there anyone who'd like to make updates to this plan right now? We are going to review this later, but we're just required to do the review, I think, sometime this spring. Okay. Since it is on the agenda, we will proceed with in-person testimony. Clerks, do we have any in-person testifiers or anyone in the chamber who'd like to testify?
Chair, there are none.
Okay. And then clerks, do we have any registered remote testifiers or anyone standing by remotely to testify?
Chair, there are none.
Okay. Members, we are in discussion. Again, this probably will come back in the form of a resolution to make changes, but we are just required to have this review right now. Okay, members, there being no discussion and no action required on that agenda item, we'll now move into executive session. The following items as posted on the agenda have been referred to executive session. I'll read the items individually to allow for oral public testimony on each item. The first is resolution to retain legal services and initiate litigation pursuant to Act 28. Clerks, do we have any in-person testifiers or anyone in the chamber who'd like to testify on this matter?
Chair, there are none.
Okay. And then clerks, do we have any registered remote testifiers or anyone else standing by remotely to testify?
Chair, there are none.
Okay. Then, in that case, I'll call for testimony on agenda item number 8, request for authorization to deem $7,010.83 in overpayment of accrued vacation leave and advance payroll to be deemed uncollectible, and that the city not seek reimbursement from a former employee. Clerks, do we have any in-person testifiers or anyone in the chamber who'd like to testify on this item?
Chair, there are none.
And then clerks, do we have any registered remote testifiers or anyone else standing by remotely to testify on this item?
Chair, there are none.
All right. Then agenda item number 9, request for authorization to settle a case against the City and County of Honolulu entitled Jonathan Perkins Sinapati et al. Versus City and County of Honolulu et al. Civil number 1 CCV 22-0000429 Circuit Court. Clerks, do we have any in-person testifiers or anyone standing by in the chamber to testify?
Chair, there are none.
And then clerks, do we have any registered remote testifiers or anyone in the chamber, anyone else standing by remotely to testify?
Chair, there are none.
Okay. Members, are there any objections to convening into executive session? Hearing none, without objections, the committee convenes into a closed meeting pursuant to HRS Section 92-4 and 92-5A4 to consult in a closed meeting with its attorneys on questions and issues pertaining to the powers, duties, privileges, immunities, and/or liabilities of the city, the council, and its committees on the agenda on the items listed in executive session. The following persons will be participating in executive session. All council members present. From the Corporation Council, we have Dwayne W.H. Pang, Paul Aoki, Daniel Gluck, Paige Ogata, and Seichi Lai Yu, Office of Council Services Staff Attorney. I'll now call for a recess. Committee on Executive Matters and Legal Affairs is reconvened. Pursuant to Section 92-4 and 92-5A4 of your revised statutes, the committee has consulted in executive session with its attorneys on questions and issues pertaining to the powers, duties, privileges, immunities, and or liabilities of the city, the council, and its committees on the items listed on the agenda for executive session. I'll now make my recommendations on the executive session items. With regard to agenda item number 7, the chair recommends that this item be deferred to time and date, to a later date as to be determined by the chair. Any discussions, objections, or reservations to deferring this matter? Okay, hearing none, so ordered. For agenda item number 8, the chair recommends that the request for authorization to deem $7,010.83 in overpayment of accrued vacation leave and advance payroll be deemed uncollectible, and that the city not seek reimbursement from a former employee be approved. Any discussion, objections, or reservations? Hearing none, so ordered. With regard to agenda item number 9, the chair recommends that the request for authorization to settle a case against the City and County of Honolulu entitled Jonathan Perkins Sinapati et al. Versus City and County of Honolulu et al. Civil number 1 CCV 2200000429 Circuit Court be approved. Any discussion, any objections or reservations? Hearing none, so ordered. That brings us to the end of our agenda, and there being no further business, this meeting is adjourned. It's 4:11. Thank you.